Good day, everyone. I am Bea Isangan and I am your reporter for today. So, today's discussion is about intellectual property rights in the educational setting. An introduction. In today's digital era, intellectual property rights or IPR are vital for protecting creators and ensuring fair use of content, especially in education. With the rise of online content, creation and sharing understanding, IPR helps address social, political, and ethical challenges related to the ownership and plagiarism. This lesson focuses on the importance of respecting IPR in education and using digital tools responsibly. The lawsuit against Ed Sheeran over his song Thinking Out Loud serves as a real-world example of how copyright laws are applied to protect creative works. For that, let us read our learning objectives. At the end of the lesson, the students should be able to define intellectual property rights or IPR, discuss the key elements of the Intellectual Property Rights Code of the Philippines or RA 8293, and identify how to assume legal responsibility when using technology, tools, and resources in education. Now let's proceed to our main discussion. ICT makes information access easier but also increases piracy. Intellectual property or IP protects creation like invention, artwork, and brand names through industrial property. And copyright like literary and artistic works. These rights prevent unauthorized use and ensure creators' ownership in the Philippines in RA 8293, or the Intellectual Property Code enforces this protection, while the Intellectual Property Office of the Philippines or IPO oversees patents, trademarks, and legal matters. So ICT makes it easy for us to access and share information, but it also leads to problems. So ICT makes it easy for us to process and to access and share information, but it also leads to problems like piracy when people use or copy others' work without permission. So that's why we have intellectual property or IP, because it protects creation like invention, artworks, and brand names, so creators get credit and control over their work. In the Philippines, this is protected by RA 8293, the Intellectual Property Code, and managed by EFOPHIL. So the Intellectual Property Office of the Philippines make sure patents, trademarks, and copyrights are properly protected. So, ICT makes sharing easy, but intellectual property or IP make sure creativity is respected. So, now let's proceed to the law protects various types of intellectual property such as first, copyright and related rights. So this protects creative works like books, songs, movies, and artworks. It means can copy or use them without the creator's permission. Next, trademarks and service marks. So this protects names, logos, or symbols that represent a company or products. For example, the Nike swoosh or the Jollibee logo on those company can use them. Third is geographic indications. This shows the a product comes from a specific place and has qualities unique to the area like Baguio coffee or Guimaras mangoes. Fourth, industrial design. So this protects the visual design or appearance of a product like the shape of a car or a phone or even a bottle. And fifth is patents. So this protects new invention or innovation, giving the inventor the exclusive right to make or sell their creation for a certain time. Sixth is layout design and integrated circuits. This protects the unique design or arrangement of circuits found in electronic devices like computers or phones. And last is undisclosed information or trade secrets. So this protects confidential business information like secret recipes or formulas. For example is the Coca-Cola recipe. So in education, this means teachers and students should always use materials that respect copyright laws, only use resources that are licensed or free to use, to honor the work or of the creators. So, in overall, intellectual property rights protect creativity, innovation, and fairness for all. Now let's proceed to in the Philippines copyright work includes. So first is literary and artistic work. So these include things like books, articles, poems, and even lectures. Basically, anything written or spoken that expresses original ideas, for example, is an author's novels of the teacher's lectures, slides. So that is first example of literary and artistic works. Second is musical and dramatic works. So this covers songs, musical composition, plays, and choreographies. So when someone writes a song or create a dance routine that protected to others can't just copy or perform it without permission. Third is visual arts. This includes painting, drawings, sculptures, and even architectural designs. For example, if an artist paint an original piece of an architect design or of a unique building, their creation are protected. Fourth is designs. So this refers to the original or ornamental or industrial designs like the shape of the chair, a phone, or a jewelry piece. If the design is new and uncreated, it is covered by copyright too. And fifth is scientific work. These include maps, charts, diagram, and scientific illustration. So if someone spent time creating a detailed map or a scientific drawing, their work can't just copy it. Sixth is audiovisual works. So these are the things like movie, TV shows, and photographs. So the director or the producer or photographers have right over their creations. For example, you can't just use or repost a movie scenes without the permission of the author. And the seven, computer programs. Yes, even software and apps are protected as original creation. When a programmer codes a new game or app, that's considered their intellectual property. So, copyright protects creativity in all its form, from books and songs and apps and films. They are giving credit and ownership to the people who made them. Let's proceed to derivative works. So derivative works, these are the creation based on something that are already exist, like translations, adaptation, or collections. For example, translating a novel into Filipino or turning a book into a movie, these are protected too, as long as they show original creativity from the new creator. So now, these are the things that cannot be copyrighted. So these include ideas, system, methods, data, news, and facts, because they considered public knowledge, and official government text and translation. So like laws or regulation, since everyone should have free access to them. And works from court, legislators, or public forums like speeches or rulings. So these belong to the public, not an individual. So next is the copyright protection starts from the moment a work is created. So you don't even need to register it registration is optional but helpful as proof of ownership. Now about the ownership. Who actually owns the copyright? So the author is the original owner of the work. And the joint works is if two or more people create something together, they share the ownership. And if a works is made as part of your job, the employer usually owns it because it was done during the duties. So, for commission, works like when someone hires an artist to design something, so the creator keeps the copyright unless there's a written agreement saying otherwise. So, for audiovisual works like movies, ownership is shared among the producer, director, composer, and writers of the original story or script. So, in short, copyright protects original creation, not raw ideas, and it gives credit to whoever made the work, making sure that creativity and fairness go hand in hand. And now let's proceed to copyright ownership of letters. So the recipient owns the physical letter, but publishing it requires the writers of their consent. Court may allow publication if it serves public interest or justice. So, the copyright ownership is specifically for letters and how long copyright lasts under the RA 8293, the intellectual property rights of the Philippines. So, when someone writes a letter, the recipient owns the physical copy, meaning they can keep it, display it, or restore it. But if they want to publish or post it publicly, they need permission from the writers or the writer's heirs. However, the court may allow publication if it served public interest or justice, like in legal cases or historical importance. Now let's look at the duration of the copyright or how long protection lasts. So for artistic, literary, and derivative works, copyright lasts for the author's lifetime plus 50 years after death. So for joint works, it lasts 50 years after the last surviving author passes away. And for anonymous or pseudonymous works, when the author's name isn't revealed or it's fake, it lasts 50 years from the date publication or created. And for works of applied art, like design or use in products, the protection lasts 25 years for creation. And for audio works or audiovisual works, such as movies or TV shows, it's 50 years from publication or creation. And for performance, like concert or theater acts, protection lasts 50 years from the date of performance. And for sound recording, it's 50 years from the date of the recording. And for broadcast, it's 20 years from the date of the broadcast. So to sum it up, copyrights gives creators ownership for a limited time. Usually, their lifetime plus 50 years, so their work and legacy are respected, but eventually shared with the public. So that are the copyright ownership of letters. And now let's talk about the author's exclusive rights. Basically, the special privileges that only the creator of work has. So first, we have the right of reproduction. So this means the author has the right to make copies of their work to allow others to copy it. For example, if someone wrote a book, no one can print or photocopy it for sale without the author permission. So next is transformation. So the right to dramatize, translate, adapt, or change the work into another form, for example, turning a novel into a movie, translating it into another language, or making a remix of a song. All of this needs the author consent. Then we have distribution, the right to sell, share, or transfer the original work or its copies. So that means only the authors or whoever they allow can distribute their work to the public. So we have that the copyrights rights. First, first is rental. So the right to rent or lend copies of the work like CDs, DVDs, or books. Next is public display or performance. So the right to show or perform the work publicly. For example, playing a song in a concert, showing a movie, or prohibiting an artwork all require the creator permission. So in short, these rights gives authors full control over their work is used, shared, or changed, making sure they respected and properly rewarded for their creativity. So that is the author exclusive rights. And now let's proceed to moral rights. So, moral rights and copyright infringement under Philippine law. First, moral rights are about giving respect and recognition to the author, not just the ownership. These include attribution, alteration, and protection. First is attribution. The author's name always be properly credited or displayed whenever their work is used or shown. And alteration, the author has the right to change, modify, or even withhold their work if they don't want it released. And last is protection. The author can stop others from distorting or misusing their work in ways that could harm their reputation. So, moral rights are all about respecting the creators as a person, not just their creation. Now, when someone violates these rights, like selling, copying, or distributing someone's work without permission, that's called copyright infringement. In the Philippines, this is taken seriously with specific penalties. So the first offense is 1 to 2 years in prison and fine between 50,000 to 150,000. And the second offense is 3 to 6 years and fines of 150,000 to 500,000 fine. And a third offense is 6 to 9 years and fine to 500,000 to 1.5 million fine. So that are the fines. And that's all for the moral rights. And now let's proceed to Optical Media Act of 2003 and RA 9239 and the concept of fair use. So first, the Optical Media Act was created to regulate the production, import, export, and sale of optical media like CDs, DVDs, and VCDs. So this disc can store sounds, videos, movies, or software that are read using a laser like on DVD players or computers. So the main goals of this law is to prevent piracy, to stop people from illegally copying and selling movies, songs, or software stored in this disk. So now, let's talk about the fair use. So fair use allows people to use parts of copyrighted material without asking permission, but only in specific situations. And if it's done fairly when deciding of something is fair. Fair use, 4 factors are considered. So we have here that purpose. It is for educational or research or for commercial gain. So educational use is more acceptable. And second is nature of work. Is it a factual or creative work? Using factual work is usually more flexible. Third is amount used. How much of the original was copied? Using a small portion of is more acceptable than using the whole thing. And fourth is effect on the market. Does it hurt the original creator earnings or sales? If yes, then it's not fair use. So fair use is activities like criticism, commentary, news, reporting, teaching, research, and even the compilation, which means analyzing a computer program to make it compatible with another system. So, to sum it up, the Optical Media Act protects against piracy of CDs and DVDs, while fair use allows limited, responsible use of copyright material as long as it's done fairly and for good reason like learning of research. So that is the Optical Media Act of 2003 and RA 9239. And now let's talk about the Creative Commons. So, Creative Commons is a non-profit organization that helps creators share their work freely but with specific rules. Yes, it provides free license that let others know exactly how they can use a work. Like if they can copy it, remix it, or use it for business as long as they follow the creator's conditions. So, we have here the Creative Commons licenses. First is CC BY or attribution. So, this license lets people use, share, remix, and even use the work for commercial purposes as long as they give proper credit to the creator. For example, if you used photo under CC BY, you just need to mention who took it. And second is CCBYSA, attribution, share, alike. So this is similar to CCBY, but with one extra rule. If you make changes or remix the work, you must share your new version under the same license. So this means others can use version 2 as long as they also give credit and keep it open for sharing. In short, Creative Commons helps balance sharing and ownership. It gives creator control while encouraging others to use and build upon with their work responsibly. And next is CCBYNC or attribution non-commercial. So this lets others use, remix, and adapt the work, but only for non-commercial purposes, meaning it can't be used to make money. The user must also credit or the creator. For example, you can use the photo for a school project but not for an advertisement. Next is CCBYNC-CA or means attribution non-commercial share alike. So this one also allows non-commercial use only and requires attribution, but just like share alike, if someone changes or remakes the work, their new version must also be shared under the same license, so everyone keeps it open and non-commercial. Next is CCBYND or attribution no derivatives. This license allows others to share the work as is for both commercial and non-commercial use, as long as they credit the creator. However, they can change or edit or remix it, so the work must remain exactly as the creator made it. And last is CC BY NC ND, or attribution non-commercial no derivatives. So this is the most restrictive license. It allows people to share the work but only for non-commercial use. With no changes or edits, the creator must be credited. In short, you can share it, but you can sell it, alter in any way. So in overall, Creative Commons licenses give creators flexibility, so they can decide whether their work can be shared freely or used to profit. It's all about respecting creativity while encouraging collaboration. So that are the Creative Commons, which are the 6 standards Creative Commons licenses. And now let's proceed to plagiarism. So, plagiarism involves representing someone else's work or ideas as your own work. Common forms include. So, when we say plagiarism, it is something very important, especially for the students like us. So, plagiarism happens when you use someone else's work or ideas and pretended they're your own. So, it is a serious offense because it's a form of dishonesty. It takes credit away from the original creator. So, here are some common forms of plagiarism. First is submitting someone else's work, like turning in a classmate essay or a project that you didn't make. Second is copying without giving credit, taking information or text from books or website and not mentioning where it came from. Next is failing to use quotation marks for direct quotes, or when you use someone's exact word but don't put them in quotes, like you don't put the owner of the quotes. Next is rephrasing without proper citation. Even if you change the wording, you still need to cite the original source, or you still put it in text citation to know where it came from. Next is copying large portion of someone's works even with citation, because that shows little original effort. So, in short, plagiarism is using someone else's work without giving them credit. To avoid it, cite your sources, use quotation marks for direct quotes, and write it in your own words. So it's all about being honest and respectful toward others' ideas. And now let's proceed to avoid plagiarism. So, how we can avoid plagiarism? Because it's always better to be safe than sorry. So here are a few simple ways. First is understand the assignment expectation. So know what your teacher is asking for, so you can create original work and not rely too much on copying from sources. Next is use credible sources. So get your information from reliable books, journals, or trusted websites so your work is accurate and well supported. Third is plan and organize your work. So don't rush. When you manage your time well, you'll have enough space to write and on your own words instead of copying others. And last is always cite when in doubt. If you are not sure whether to cite someone or something, just cite it. Giving credit is always better than accidentally plagiarizing. So, to sum up it, to avoid plagiarism is about being honest, organized, and respectful for other people's ideas or works. In conclusion, in educational setting, understanding intellectual property rights or IPR is essential for both teacher and students. Copyright, moral rights, and licenses like Creative Commons protect the work of creators while ensuring fair use of learning, teaching, and research. Laws like the Intellectual Property Code and the Optical Media Act help prevent piracy and misuse of materials. while concepts like plagiarism remind us to respect others' ideas, and give proper credit. By following these rules, using credit sources, citing properly, and respecting creators' rights, we not only stay legal and ethical but also foster a culture of honesty, creativity, and respect in education. So that's all for my report. Thank you for listening. Bye bye.